Greetings, welcome back to episode 4 of our review of the courts and trials process. Today we are on episode 4, Prosecutors. It's our second in our 3 parts looking at the different court actors. We started in episode 3 with public or defense attorneys, then we moved to prosecutors here in episode 4, and our next episode will look at judges. Prosecutors, you could argue, are the most powerful figures in the criminal justice system. And 2 particular quotes from the late 1930s into the 1940s sort of demonstrate our thoughts about prosecutors and how we view prosecutors even today. The first came from Attorney General Robert Jackson as he addressed federal prosecutors. He said, "The prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous. He can have citizens investigated, and, if he is that kind of person, he can have this done to the tune of public statement and veiled or unveiled imitations. Or the prosecutor may choose a more subtle course and simply have a citizen's friends interviewed. The prosecutor can order arrests, present cases to the grand jury in secret session, and on the basis of his one-sided presentation of the facts, can cause the citizen to be indicted and held for trial." This idea built on an idea from the United States Supreme Court in a case called United States versus Berger. The Supreme Court wrote, "The United States Attorney is a representative not of an ordinary party to a controversy, but of a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern at all, and whose interest therefore in a criminal prosecution is not that it shall win a case, but that justice shall be done. As such, the prosecutor is, in a peculiar and very definite sense, the servant of the law, the twofold aim of which is that guilt shall not escape or innocence suffer. He may prosecute with earnestness and vigor, indeed he should do so, but while the prosecutor may strike hard blows, he is not at liberty to strike foul ones. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one." And these 2 quotes really demonstrate the power that the prosecutor has, that using this power can result in false convictions, it can damage people's reputations, and therefore we really need to understand how prosecutors work and what that is that they do. First, it's important to understand we have 2 different types of prosecutors that we are dealing with. The first is federal prosecutors. These work on federal crimes. They will handle everything from major drug cases to human trafficking cases. They will deal with major fraud cases. They'll deal with national security cases. They'll deal with immigration matters. All of these cases create their own individual problems. They have their own individual issues, and prosecutors must work in those different areas and usually will specialize in some of those areas. They are known as United States Attorneys. They represent the United States government. They're appointed by the President. They are confirmed by the Senate, and they serve at the pleasure of the President. They work in conjunction with the United States Department of Justice, so the President also has the power to appoint the Attorney General, and that Attorney General also is confirmed by the Senate. Both the U.S. Attorney and the Attorney General are presidential appointees, this sometimes will create conflict between the 2 agencies, but the Attorney General will have the final say in most instances about what happens. There are 93 different United States attorneys throughout the country, 1 in each federal district, and then each U.S. attorney has a different number of assistant U.S. attorneys who handle the cases on a day-to-day basis. Contrast that with state prosecutors. There are many, more state prosecutors in the United States than there are federal prosecutors. There are many more state crimes prosecuted than there are federal crimes. And state crimes are going to cover the typical things such as murder, robbery, rape, stealing, and minor drug offenses. The selection methods for state prosecutors are going to vary considerably from place to place. Most of them are going to be elected by the people in their particular jurisdiction. So a prosecutor may represent one or more counties or a particular area of the state. However, they would be elected by that group that they represent, which holds them separate and apart from the state attorney general, who would oversee things on a state level. State prosecutors or local prosecutors handle things on a local matter, and they're not answerable to a larger state body. This holds true in most states except for the states where they appoint their local prosecutors, and these tend to be some of the smaller states geographically. So you'll have states like New Jersey, Connecticut, Delaware, who don't elect district attorneys. Instead, they're going to appoint those people, and the Attorney General will generally make those appointments, or in some instances, the governor may do that as well. In addition to that, they're going to go by lots of different names. So you may have a district attorney in one state, you may have a state's attorney in another state, you may have a prosecuting attorney in a third state. The label doesn't matter, they all tend to do the same work. So what is it that these prosecutors do? Well, the key piece of the prosecutor's work is simply the discretion that they have. They have a wide range of things that they can do and choose to do or not to do, and very little is going to oversee that discretion. So the first thing that prosecutors are going to be involved with is usually the charging decision. So as we talked about in episode 2, when the police make an arrest, they're going to take the case to the prosecutor, who will then review the case, determine if there is sufficient evidence for the case to proceed into court. If the prosecutor is so inclined, the prosecutor can even go and participate in the investigation, and that may entail giving directions to the investigators. It may be actually going and collecting evidence with the investigators. It may be drafting search warrants. It may be interviewing suspects or witnesses involved in the particular incident. So prosecutors can make tons of different choices on any given case about what direction it's going to go. In terms of the charging decision, they decide whom to charge, they decide what crimes to charge, they decide how many to charge, and they decide when to charge. And so if you have an ongoing investigation, the prosecutor may begin with one particular charge, and as they continue to investigate, they find additional crimes that have been committed. And so those crimes can be added on. They may find multiple people were involved, and they may choose to work with some of them as informants. Others may get charged criminally. Finally, they can decide when they've investigated enough, and when they've said we've gotten all we can get, it is time to move on. And so they decide when to file those criminal charges. When they're making these decisions, lots of different factors come into play. In any given case, the facts are the most important factor that goes into the decision-making process. Prosecutors need to have good facts. If there are lots of disputes about the facts, if there's ambiguity about what happened, if there's lots of conflicting witness testimony, or the scientific evidence indicates at best inconclusive results, then prosecutors are going to be less likely to file the criminal charges, because they have to be able to go into court and prove their case beyond a reasonable doubt. And if there is lots of conflict at the beginning of the case, cases are not like wine. They're not going to get better with age. Instead, they're only going to get worse. And so if they can't make the case beyond a reasonable doubt at the charging stage, the chances of them being able to make that case at the trial stage becomes even less. But yet beyond that, then the prosecutor has to look at those facts and interpret the facts. They have to recognize there's ambiguity. They have to recognize there's conflicting witness statements. They have to think about how do these facts apply to the different legal elements that the prosecutor will have to prove in court. And this is where we start getting individual factors, because some people are better at that than others. Some people are better at spotting issues. Some people are better at interviewing other witnesses than others. They're able to get the information that they need to get, or they simply overlook it or they miss it. Some don't have as much experience. They don't know what to look for. Some have certain specialties, and so they know to look for particular things, where someone who doesn't have that experience or that specialty may not know to look for those things. Beyond the individual factors, you have office factors that may influence a prosecutor's decision. The office may set policy and say you must have certain facts before you can file particular criminal cases. So for example, if you have a marijuana case, the office may say we are not going to prosecute a marijuana case unless there is at least 1/4 pound of marijuana, in which case then it becomes significantly more likely that the charges will be filed, because the office has said if we have more than that amount, we need to file the charges. You may have offices that don't like particular types of crimes, or there may be a particular crime problem in a neighborhood, and so the elected prosecutor says we need to focus on this particular type of crime, and so those cases become more likely to get filed as a result. Beyond that, you have the wider courthouse factors. Judges, defense attorneys, they're going to make their thoughts known about the case. Especially judges, they may not like particular types of cases. So for example, you may have police decide to arrest drug addicts by setting up fake drug buys. And they're selling them fake drugs, and as a result they get charged with attempting to possess a controlled substance. The judge may say that's incredibly unfair, that it's a misguided policy, and make their ideas known to the prosecutor's office, who then will go back and say, look, the judge doesn't like these cases, let's not file them anymore, let's not work on these cases. And so there is that interaction. And then there's the larger community aspect. As we already talked about, there may be a community crime problem, and so the community is applying pressure to prosecute a certain type of case. There may be business leaders or political leaders who want certain cases filed, or want to focus on a particular area of the jurisdiction and say, we have a crime problem in this corner of the town, we need to address that and we need to emphasize that. All of these different factors are going to come together when we are deciding what cases to prosecute and whether or not to file charges. So once the prosecutor has made the charging decision, that sets the stage for the plea negotiation process. As we have talked about in prior episodes, 90% of all criminal cases end up as guilty pleas. And so the prosecutors, through their charging power, have the ability to generate some leverage in these negotiations. The first way they do that is what we call overcharging. They get to decide what the charge is, and if they want to charge something more serious than what they think they can actually prove in court, then they can negotiate it down to what they think they can prove and not give up anything, even though it looks that way from the outside. And the U.S. Supreme Court has said using this power is okay. This is part of the give and take of plea negotiations. It's still a voluntary choice on the part of the defendant. This, of course, raises the question of prosecutorial ethics. Is it ethical to overcharge? Is it ethical to increase the stakes or make it so that a risk-averse defendant doesn't want to exercise the defendant's right to a trial? And we don't have good answers for this question of whether it's ethical or not. Some prosecutors would say yes, some prosecutors would say no, some judges would say yes, some judges would say no. Instead, what we have is different perspectives on the prosecutor's role. And that's really the source of the answer to this question, or how we answer that question. And what you will find is, historically, we have 4 different types of prosecutor role perspectives. And depending on the type that the prosecutor adopts, is going to influence the decisions the prosecutor makes. So our very first type that we have is what we'll call the private prosecutor. This was the original role of the prosecutor. We've inherited our system from the British, and they used a system of private prosecution where the victim of the crime would have to go hire an attorney to present the case in court. The prosecutor was not the representative of the state. The prosecutor was the representative of the victim who was harmed. And as a result, there became that connection between the prosecutor and the victim. The prosecutor didn't care about truth or the accuracy of the claim. The prosecutor was more concerned about getting a conviction, because that was how the prosecutor got paid. This lasted up until in most places, the early 1800s, and especially in the United States, the prosecuting power was turned over to the government. And in the early 1800s, there was a strong democratic movement where we began electing our prosecutors rather than having them be hired by victims or appointed by the court. And so when we talk about political prosecutors, we're talking about prosecutors who understand that they have to appeal to both the political party that they represent and to the general public who will elect them. As a result, political considerations begin factoring into prosecutorial decisions. And so we will begin to make decisions that benefit the party and maintain job security rather than what might be just. We're not interested in justice yet. We're more interested in, can we benefit the parties? By the early 20th century, this started to give way to what we call more a professional prosecutor role. This is where prosecutors are acting in the interest of justice. It's the source of those quotes that we started out with, that prosecutors represent the state, and it is their job to seek justice and to make sure they follow the proper procedures. This is where prosecutors began becoming more involved in the investigation. They began using their discretion for policy purposes. So they would focus on particular types of crimes at particular locations or at particular points in time. Eventually, that has now started to give way to what we call more progressive prosecutors. These are prosecutors who are working with the community to solve community problems. They are trying to find ways to soften the criminal justice process to make sure that the punishments are not as substantial or as punitive. They're trying to find ways to be more fair in how criminal justice policies are implemented, and they're taking a much more holistic approach to the work of the prosecutor. And so depending on the particular role that a prosecutor adopts, they're going to respond differently. A political prosecutor may see a case and say, hey, this has some political benefit to us, whereas a private prosecutor may say, look, there's no money in it for me. The victim here doesn't want to pursue the case, so we're not going to go forward. Whereas the professional prosecutor may say, we don't care what the victim says, we don't care what the political benefit is, we have significant evidence here of a crime, it's our job to go forward. Where the progressive prosecutor is going to again look into the background of that case and begin pondering what we can do to address the underlying problems that led to this particular offense. This then leads us to a question of who actually is the prosecutor's client. We have several different options for this. If you are a federal prosecutor, usually the answer is, I represent the United States government. And that is different from the United States people. Right? So just because the people say something, the prosecutor at the federal level is going to represent the government and what the government's interests are. On the state level, it becomes a lot more ambiguous. Again, you may have the government. We represent the government of North Carolina or the state of North Carolina. It's not uncommon for prosecutors to get up and stand before a jury and say that they represent their particular state. But other prosecutors are going to say it a little differently. They may say, we represent the people of this particular state. And that's certainly a different way of looking at it as well. Of course, the government, the people, they don't speak like an ordinary client might. They don't give directions like an ordinary client might. And so that changes how how prosecutors respond. We may also see prosecutors who still represent the victim, and they believe that their job is to do whatever the victim wishes in that particular case. Others may see the police as their client. They will give legal advice to the police. They'll instruct about search and seizure issues. They may instruct about investigative techniques. But ultimately, they're going to be looking at the police as the client. There may be some who see the chief executive, so the governor of the state or the mayor of the city or the county council as their particular client. Finally, I would argue, especially as an assistant prosecutor, the assistant prosecutor's client is the elected prosecutor. If we are working from a democratic theory, the elected prosecutor is the voice of the people. The people have placed that prosecutor in office because that prosecutor has particular policies and ideas, and as a result, that person then is the client. I would recommend, as you begin thinking about prosecutorial power, exactly how that may influence any given case, especially as you go and watch court. Look particularly at what the prosecutor does. And I think you'll find that amongst all the court actors, the prosecutor has the most substantial power.